Taha Tarawera.
The question is that the motion be agreed to. For Nikki Wagner.
I rise to take a call on this resource management restricted duration of certain discharge and coastal permits amendments bill in the name of Catherine Delahunty. And thank you, Catherine, for bringing it to the House, and thank you for speaking so passionately about it. Now, the purpose of this bill is to limit the time period of which a discharge permit or coastal permit may be issued to 5 years. And that is when that permit has been issued under exceptional circumstances. And I have to say, on face value, that seems like a sensible idea and attractive. And I had an open mind when I first had a look at this bill, and particularly in reflection on what Catherine said about the Tarawera River. But there are actually a variety of good reasons why under Section 107A, 2A, the RMA provides temporary consents. And in some cases, not necessarily in this one, but in some cases the 5-year limit may actually increase the adverse environmental and economic impacts. Now, we've heard from Catherine about her concern about the consent issues for the Kawerau pulp and paper mills and about the discharge consent which has been granted, and for the length of time that it has been granted, which is another 22 years, I think. And I do respect her concerns, and certainly we want to clean up our rivers. And after listening to the description, and for the people who were so concerned about the river, it sounds like we need to do something about that. And in actual fact, there has been some improvements, and she certainly also noted that, because when the consent was last renewed, it reduced the discharge significantly, and the amount of the discharge actually reduces during the time of that consent. So it is a downward spiral. And already the mill is discharging 33% less now than the consent actually allows for, with that continuous improvement. I also note that this consent and others have sought under this provision have been appealed to the Environmental Court. And in each case, the Environment Court has actually applied a pretty rigorous test to validate the exceptional circumstances, and they've reaffirmed the conditions of the permit issued to minimise environmental effects. This indicates that, in actual fact, the process is pretty carefully considered and only used where appropriate. Actually, it shows that the section is doing exactly what Parliament envisaged when we wrote the legislation, allowing time to find ways to clean up discharges in the cases of exceptional circumstances. It's now more than 20 years since the RMA was introduced, so it is time to look closely at that legislation, and National is committed to updating, to streamline, to simplifying the legislation, and to make sure that it adequately manages contemporary issues. But I don't actually think this bill will improve the legislation. The Section 107.2a, which this bill seeks to amend, is actually very rarely applied. And there's no evidence, except perhaps in the case of Tarawera, that it has been misused. 107.2a affects only a very small number of relevant consents because exceptional circumstances are indeed exceptional. And any change to the law wouldn't affect any of the existing consents, and Catherine Delahunty has actually said that tonight, such as Kawerau. And we actually don't expect many to be granted under this in the future either. So, because it has a very limited use of this section of the RMA, because when it has been used, it has been validated by the Environment Court, and because there's very little evidence of abuse of the section, and because it's only used in exceptional circumstances, I'm afraid National won't be supporting the bill.
I call Moana Mackie.
Thank you, Mr Speaker. I'm happy to take what I think will be a short call on this piece of legislation.